Namaste. In the previous discussion, we discussed about the mediation agreement, that is section 4 of the Mediation Act 2023. Now in this video, we will discuss about the pre-litigation mediation defined under section 5 of the Mediation Act 2023. So pre-litigation mediation is a critical mechanism that allows the parties to resolve the dispute amicably before initiating any formal legal proceedings. This section outlines the framework for conducting pre-litigation mediation under the Act. So, the provision lays down that the parties may voluntarily, whether or not they have an existing mediation agreement or not, can voluntarily opt for pre-litigation mediation with mutual consent before filing of any suit before the court of law. This promotes the dispute resolution mechanism without resorting to the court proceedings. Under the Commercial Courts Act, Section 12A, which has mandatorily required to refer the commercial disputes for pre-litigation mediation. In commercial disputes of a specified value, pre-litigation mediation is must comply with Section 12 and its associated rules. This ensures a structured approach to mediation in significant commercial matters. So pre-litigation mediation is applicable even in case if there is an existence of a mediation agreement or not, as stipulated in the previous section, that is section 4. The provision also extends to the tribunals as well, notified by the central or the state government, emphasizing a broad applicability of pre-litigation mediation across various judicial and quasi-judicial bodies. In order to ensure that the mediators or pre-litigation mediation should be resolved through qualified mediators, a specific clause has been included in Section 5, a mediators for pre-litigation mediation. The mediators conducting the pre-litigation mediation should be either they must be registered with the council, that is the mediation council established under Section 31 of Mediation Act of 2023, or either they must be empaneled with the court annexed mediation centers, that is the mediation center established by courts or tribunals, or they must be empaneled by an authority under the Legal Services Authorities Act of 1987, or either they must be empaneled by a recognized mediation service provider under the Act. So this ensures that the mediators are qualified and recognized by relevant authorities, maintaining the quality and credibility of a mediation process. So for the purpose of the pre-litigation mediation, the parties can request a mediator through a designated person by the High Court or the authorities under the Legal Service Authorities Act of 1987. This clause facilitates the easy access of qualified mediators for the parties to resolve their dispute by means of pre-litigation mediation. Further, this section 5 of the Mediation Act also mandates the court annexed mediation center and the Legal Service Authority, that is authorities established under the Legal Service Authorities Act 1987 to maintain a panel of mediators specifically for pre-litigation mediation. A panel of mediators, that is a mediators empaneled with a court annexed mediation center or the authority Legal Service Authorities Act. This ensures that the availability of the mediators for parties seeking pre-litigation mediation. This section also promotes the pre-litigation mediation in case of motor vehicle accident claims, which was even stipulated by Justice Sri Krishna, wherein he was recommended to establish a special mediation cell for resolution of motor vehicle accident claims. In reference to that, a special clause has been included under section 5, that is, in case of compensation claims arising from accident, if a settlement under section 149 of the Motor Vehicle Act 1988 is not reached, the claims tribunal must refer the parties to mediation. If settlement is achieved, the agreement is submitted to the claim tribunal for approval. If no settlement is reached, a non-settlement report is forwarded to the tribunal for further adjudication. This provision integrates mediation into the claim process, promoting amicable resolution in accident compensation cases. In general, or in conclusion, the pre-litigation mediation provision inserted under the Mediation Act by means of section 5 are designed to encourage the parties to resolve the dispute amicably before engaging into formal legal proceedings. By providing a structured framework for mediation, these provisions aim to reduce the burden of courts, expedite the dispute resolution, and foster a collaborative approach to conflict management. So with this, we conclude the discussion on pre-litigation mediation. Thank you.